If you pay your terminally ill friend's medical bills, can you later seek reimbursement from her estate? What if you pay your terminally ill aunt's medical bills? We explore a similar question in Estate of Frances Cleveland versus Gordon. Frances Cleveland was an elderly woman who lived alone. In 1976, Cleveland executed a will in which she left most of her furniture to several nieces and nephews, including Jane Gorden. Cleveland left the remainder of her estate to her church. In 1984, Cleveland fell ill. A neighbor contacted Gordon for assistance. None of Cleveland's other relatives were willing to help, so Gordon traveled to Cleveland's home from out of state. When it became apparent that Cleveland needed more care than Gordon could provide, Gordon placed Cleveland in a nursing home. At that time, Gordon met with Cleveland's bank and inquired about the possibility of obtaining reimbursement for expenses Gordon paid on Cleveland's behalf. The bank assured Gordon that she would be entitled to reimbursement if she established a separate account for payments and kept detailed financial records. Gordon followed the bank's advice. Cleveland knew that Gordon was paying Cleveland's bills and even told an acquaintance that Gordon would get everything Cleveland had at the time of her death if anything was left. Cleveland died approximately 5 years later. Gordon filed a timely claim for reimbursement from the estate. Although Gordon sought to recover the amounts she'd paid for Cleveland's care, she didn't seek compensation for any services that she'd provided to Cleveland. The estate's administrator objected to Gordon's claim, asserting that she wasn't entitled to reimbursement. Specifically, the administrator argued that Cleveland had never expressly promised to repay her niece, and therefore that Gordon's payments were gifts. The probate court found in the administrator's favor. Gordon appealed to the Tennessee Court of Appeals.